This is going to be a very weird recording. I have dealt with these issues in other recordings, but I can't even point to which ones those are. But oh well, yeah, they are all related to my commentary on Lord Sumption's Reed lectures on Law's Expanding Empire, or something like that. It was the first lecture, but the series on uh, essentially how law is encroaching, or the expansion of law is encroaching on basic fundamental values. Perhaps is one of the themes, and dissecting that kind of intellectual issue. Now, I must say, I haven't. It's much easier for me having, if I've listened to these lectures recently. It's much more easy for me to articulate my arguments, which might be slightly messy and might be more cogently and forcefully put in those comments. But because I will be recapitulating essentially a lot of those points, which I think now come to a head more poignantly in the current semi-constitutional crisis, and I would like to frame it as a constitutional crisis. Perhaps that constitutional crisis can be avoided, but I see it as a fundamental impasse because of the failure in the structure of the American legal system. The American legal system is fundamentally inadequate. Now, um, that's quite a high critique to claim. There's quite a grand, criticism to make. I'm going to. I might not with brilliant eloquence explain it, but I think that if anyone charitably um, reviews my remarks and cleans up the lack of legal specificity in stating things in quite the precise way that the American legal system semantically, sort of frames it, that you will get the point quite clearly. That if you look past certain technical inaccuracies, which are to some extent somewhat, I guess, with someone who has done, let's say, I have researched this in the past, but I won't exactly be able to translate the principles into the American system. But speaking from beyond the system, outside the system, and which is the only way that you can say that a legal system is inadequate, is by stating that there is an alternative. There is another system that would not have these deficiencies and inadequacies. Okay, so let me vaguely, in an aggregate sense, frame what the deficit is. So, the basic point is that in the American legal system, judges are interpreters of the law. They do not make the law. They, in some sense, they can discover the law in interpreting it to some extent, but they don't substantively extend the law from the bench. It all comes from the, at least in the originalist and the textualist approach, which I believe is the correct approach to take when you are dealing with legislation. Now, the problem that I'm stating is that fundamentally the only thing you have to work with as a judge is the constitutional framers, in some sense, their original intentions, and the intention of the legislature. And in some sense, in the extent to which that you, um, let's say to some extent, economically interpret their their intentions, you do so in order to give maximum effect to the overarching coherence of the legislature's fruits. Sorry for the slightly imprecise and poetic language, but that essentially the only time that you ever sort of tactfully interpret the legislature's purport and intention and framing is essentially to provide a more coherent form of law which has been provided by the legislature. Now, this is the basic problem, is that the only thing a judge is allowed to do is contend with that directly, is the legislature itself, and perhaps the framers of the Constitution. That is the ambit of your inquiry. And so you have to hope that the fruits of those intentions and of those framers, that they render solutions to every problem, that they render uh, um, sufficiency, to every or to bring clarity over what issues should prevail, and at some point you can't have judges function like this, because judges cannot just be secretaries. And now in the American system, they have to stay secretaries, because there is no substantive arm of the law that exists other than to direct a judge to be faithful to some kind of interpretation. Um, and the living document stuff is complete trash. That you're going to sort of take a modern interpretation in order to extend. Like, I'm sympathetic to that in some sense, but it is certainly trash. I mean, that is the worst outcome that you could possibly have. So I am almost sympathetic to both ends, because if you are going to interpret legislation, if you care what the actual interpretation is, and in some sense you should, but then you should also have higher, greater substantive ideals or principles that you live up to. And this is what is conspicuously lacking in the American system. There are no higher ideals. The only higher ideals are something like the Constitution, which are not a full set of legal principles. They are particular absolute rights, which are also a bit stupid to have, because essentially they are given such little effect. They are interpreted into being in such a I mean, this is a slight tangent, but it's worth going into. But I mean, essentially, what is the right to pursue happiness? I mean, it's a useless right. I mean, can I say, well, I have a vision for my life that I should be in a certain profession, and that's how I wish to pursue happiness. And now I can't be in that profession because there's a license in my way to being that thing. Or I want to engage in a certain commercial type of exchange, and now I can't do it because that kind of exchange is made illegal. Um, I don't want to pay income tax because I see that as an opposition to me achieving the pursuit of happiness. Can I use the right to pursue happiness as a bulwark against any of these interferences? No, I can't, because they're all already selectively interpreted in order to endorse state power or something, or in some sense to endorse the legislature. So they already are not absolute. They are twisted and contorted in order to provide backing and cover, that the judge is there essentially in order to enshrine the power of the legislature. The legislature is the tyrant in some sense. And the only excuse for this is that, well, there's a democratic mandate that is provided from the people to the legislature, so it's all fine. And where is the substantive justice in this? It's conspicuously lacking, it's missing. Now, in some sense, I can't say that when the American Constitution was set up and when the legal system was set up, that there weren't alternatives, but they probably weren't known about. There's only one alternative in the world which has a full canon of legal principles, and those legal principles are a closed system and they provide for everything, and that is the Roman law, which essentially no longer exists anywhere in the world apart from the Roman Dutch substantive law that exists in my country. But my country is a beleaguered country that has been ravaged by say contemporary history, And those principles have been that form of law, that structure of law, which is actually superior to the other legal systems, has gone betrayed because of what I can only call as the general atmosphere of insanity that has been promoted by the the corruption of legal systems, which was built into the American system because they basically followed the French influence. Um, the Napoleonic corruption of law is generally what I would call it, which is that you are a kind of peon of your legislature. Your legislature is your now. If you are already going to concede that, well, you're always going to be in the power of your legislature, and your courts, you can't expect your courts to stand up against your legislature, so you structurally already make them allies. And then what you do is you give people an absolute constitution which kind of works on a political level because it's like a political promise, and you can use it as a kind of as political rhetoric in order to unseat legislatures that don't live up to those ideals. So it's not, it's more of a political protection. The Constitution is much more of a political protection than an actual legally defensible. Um, so it's not without its merit. It's not without its design. But in terms of the legal protection that it provides, it's completely inadequate and substandard. And I say that because there is an alternative. Because you could have substantive principles, general principles that govern legal development, and then you could have essentially, you wouldn't have to have judges bringing in their personal interpretation of some living document or something like that. They would have legal principles with which to discover new law and to expand the common law by essentially taking novel, modern controversies and applying the same canon of principles to those problems. And that canon of substantive principles means that then judges could defend the moral culture of a society, and that would not just be left to the legislature, which they are, frankly, legislatures are not really equipped or able to really defend the moral sanctity and or at least the natural cultural institutions that underpin any kind of society or civilization or value structure. Legislatures perform this very badly, and this also leaves a certain gap in the American law. I mean, this is why, for example, in the McCarthy era, when they had the Red Scare and they had the commission of anti-American stuff or whatever, which is frankly pretty much needed now in order to sort out all this very disgusting far left identity politics that has completely fused itself into academic, it's like a cancer in terms of how it spreads. I'm not going to substantiate all of that perfectly in terms of a legal setting, but if you just take that as common cause, the 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 problem with essentially the McCarthyist thing is that it was not done by judges, because that is something that could never have been done by judges. It was done by a commission. It was done by politicians, um, and it was slightly extra legal. It was slightly, the whole validity and legitimacy of the whole thing was very sort of strange. That is really something that you want judges to do. You want judges to defend certain sacrosanct cultural, natural institutions that underpin values and things like that, and you want it to be an objective law. You want it to be laid out, but you'll never have those values laid out in the American legal system because judges aren't supposed to have substantive moral insight onto issues. They're only supposed to interpret the original moral insight. And even if they weren't supposed to interpret the original moral insight, they certainly aren't supposed to bring their private views and inject them into the arbitration. So you see, there is a conspicuous lack of principle uh, uh, that essentially then you are just completely in the hands of the legislature, and the individual is completely neutered and overpowered and overshadowed by the legislature, and has no real recourse. The Constitution is almost of no help for the individual against the state, because the judges already have these somewhat strange moral principles. Sorry, not moral. Already have these strange principles of interpretation to essentially conserve the efficacy of the legislature above all other concerns, pretty much. Other than, let's say, the original intent of the framers of the Constitution is the only thing that trumps the the other bodies and the other either the Congress or state legislatures. Uh, okay, so sorry, there's another point here. Um, so I mean, the real problem is that judges can't just be secretaries. They have to defend a substantive sort of value system, which they are literally bad judges if they do that in the American legal system, because there is no closed system. There is no closed system of principles. There is no solid framework. And let me just give some propaganda for the Roman law for a second. You realize that the Roman law had a whole separate legal system just to deal with foreigners and their foreign law and their foreign customs, and coming from different legal systems with different ideas and different principles. The Romans had a whole legal system just to deal with people that have other ideas in their head about what justice should be and what justice includes, and how those customs should be incorporated and respected and sort of and be given effect, because they had putative ideas about how things operate. You know, how could you have such an advanced legal technology unless you had such amazing legal principles? In fact, you have so many legal principles that some are even never used because the system is just so brilliant. I mean, it really is a marvel of, these principles have been generated by human genius over generations. They have been refined, their interpretation have been refined, they have been absorbed. It's a marvelous system. It really is. So anyway, my propaganda pitch over. But okay, and this is the basis of my country's common law. The substantive arm of the law is Roman Dutch. It is the Roman law as it was received by the Dutch, which no longer exists in Holland. It no longer exists in the Netherlands anymore, because Napoleon took over Europe and destroyed every other legal system and imposed his Napoleonic codes. And therefore, the greatest legal system in the world was overshadowed by a form of legislative tyranny, because of the paranoid excuse that that the people must be sovereign, and therefore, the majority becomes a tyranny. And essentially, in America, the only recourse is trying to get your fellow citizens to vote the right direction against tyranny, using the Constitution as a kind of rhetorical resource. Anyway, okay, so that is my reading and interpretation of this. Of the kind of situation that America is in. And this means that, especially in terms of elections, you are screwed. Because essentially, I mean, let me just make some general substantive claims here, is that certain states have, via their own legislatures, they have destroyed the integrity of their own elections. They have brought down the security of their elections beyond a certain tolerable level. They have brought their own elections down into disrepute. They have destroyed the validity of the results of the elections as they conducted them with in terms of the you know and in some sense the people who suffer are not just the people of that state or but especially the people in other states, because the people in other states now um, are having their election contributed to by essentially delinquent, substandard, sort of defective, in some sense, kind of clearly morally defective and questionable um, procedures, which were in fact designed on the face of it in order to lower the security of the election. Um, so the legislature, these legislatures have gone rogue, and there is essentially the only way that you can correct those rogue legislatures in terms of the Supreme Court, which is really the body which is most put in the quandary that I set out at the beginning of this recording, is that the only way that you can rebuke, as it were, and morally defend and protect the, let's say, the culture of democracy in America is by using the Constitution as a magic 8 ball, shaking it up, finding the bits of it that can be made to be seen as relevant, and then interpreting the answer of this magic 8 ball as to why these legislatures have failed in some kind of constitutional duty. And this way of doing things, again, is half in the dark. It's not desirable. It's deficient. It's inadequate. Now you can get away with doing this, but it's going to be divisive anyway, because they aren't very clear principles backing you up, and you are in some sense drawing on the you're extending precedent. You're discovering new law in the old law or something like that via interpretation. Um, but the actual and you have to do so by pretending to suppress your own sentiment, because you can't just say, well, actually we're using these principles. So you have to pretend that you have no sentiments when it's what could you be doing to extend the interpretation of certain constitutional things other than relying on some kind of extraneous inclination or sentiment. I guess the only thing is that you say, oh, well, these sentiments would obviously be sympathized with and shared by the constitutional framers, and maybe they just did not actually make provision for everything, which I think is the biggest problem. Is that some things they clearly did make provision for, and some things they clearly did not. And if the legislature or the constitutional framers are mute on an issue, or silent on an issue, then you have what I would call the constitutional um, crisis, especially in the case of the fact that how can the legislature provide clarity and let's say final recourse when the legitimacy of the um, procedure that derives their appointments is the thing that is in question and the thing that is faulty. So I mean, in some sense, I think that this is the perfect storm in the American system, in some sense, to make my case that I have been making for a long time, which is that the American legal system is fundamentally inadequate and deficient. That it is wrong in structure, and you cannot expect the legislature to protect the culture the values, of a society. You cannot expect that. In practice, that they will be the first line of defense, but the judges, in some, I mean, and I know it's not nice to have judges do more of this kind of work, because then it feels like as if your society is controlled by judges and not by some kind of potential plebiscite. That you can't have a kind of a self-directed, self-ruling people, and instead you are being ruled by a set of principles that force a kind of coherence, that force a kind of accountability and reasonability. Now, in some sense, I think that is the final effect of these, when you have a closed system of principles, is that you're not stopping the invention of new ways of doing things, but those inventions have to comport to, let's say, certain almost natural laws of how you would create mechanisms and procedures. And they must be harmonious with those things. Now, right now, there are some secondary principles in the legal system, in the American legal system, but and they primarily come from some, what I would even say, arbitrary, prominent um, dictates that can be fielded from the Constitution. And I would say that that kind of quite sparse protection is not good enough, and it's certainly conspicuously not good enough in what I would frame as a fundamental constitutional crisis. Not, in some senses, not a constitutional crisis, because in some sense I think that almost nothing can be done. I might be wrong, because I have not studied the Constitution and I have not studied everything that it says about elections. If there isn't some argument that you can make that essentially these states have let down the Union, and that is intolerable, and there is a certain basic threshold that must be imposed on states that are severely compromising the security and the integrity of their elections. I mean, I think that it's almost the kind of fraud that probably took place, or that is alleged to take place, is probably not capable of being remedied except by rerunning the election. I mean, I would say that you would either have to have a completely different standard of mail out ballot that has more signatures on it, and that is actually checked by people who are observing from outside the state, or something like that. I mean, the mere fact that things happened without observers um, present means that essentially I think the whole thing is defective beyond um, effective beyond repair. I think I don't see a way that you can guarantee the idea that you had a fair election unless you basically rerun these elections, because I think that it's probably been spoiled to the extent, I mean, the extent to which that new ballots have been, I mean, so you had these activist people who were running these election counting operations, conspiring essentially to be these kinds of these Democrat superheroes, that they believed all the propaganda that every vote must be counted. It doesn't matter if it came in after the election day. So let's just shuffle them in, because then they can't be extracted. Um, and then also you have the harvesting, which is something that you know because essentially the procedure was not robust enough at protecting against vote harvesting in mail-in ballots. That is a defect which there doesn't even exist a paper trail, and that I would call that an intolerable breach of security, essentially. So I mean, I think that you would have to run these elections again, have them only in-person voting, um, have it only on a paper trail. In some, there should be basic standards um, set out to some degree. But I mean, the Supreme Court, I don't know if it has that. Uh, what would be the source of law that it would use to impose such stricture? How could it come to such a conclusion? Because at some point it's going to sort of, even if it sources some moral authority from interpreting the Constitution, where are these criteria going to, you know, they can be legally excused, but how are they going to be, essentially you're going to have to be arbitrarily imposing a set of criteria until you say, until the federal legislature or until another legislature has supplemented this criteria for a criteria which is as good as this or something like that. And I don't think that the Supreme Court will even want to do that. They will want to avoid that kind of conspicuous, um, ugly, because according to the American legal system, that is a very ugly sort of outcome. It's very unsatisfactory. It kind of, because then you say, well, these judges are making new law. Um, when they're only supposed to be interpreting things, and now they are, because usually when there's a controversy, the case can only even exist, um, because it contravenes some existing legislature structure that is not being followed. That is the only thing you have to stand on and try to argue from and defend, and to promote the exaltation and amplification of the non-application, purportedly or allegedly, of that piece of legislature. And I think that these issues very clearly need to go beyond legislature, because in some sense the problem is that the legislature was colluded in engineering low security or low integrity elections. Um, so it is interesting that in my legal system that I'm proposing as an alternative, the judiciary does actually become more powerful than all other branches of government to some degree, but they are internally regulated by their own principles, which are clearly defined so well, and such a closed system of principles that reason itself is the only defense in some sense. Reason and accountability, as borne out in the case law, as it were. And it's not as if that those questions surrounding these principles reach immutable conclusions. Sometimes judges do go the wrong way, and then their judgment gets revised in some sense, through, I mean, that's the point of precedent. That's the point of review. But at the end of the day, it is there is something to be said about exalting reason and accountability. And if you don't put reason and accountability on a substantive pedestal that is given effect in a legal system, you invariably create a kind of philosophical, metaphysical gap. You create a wasteland, and I think America has now actually, in this perfect storm, they have reached this impasse. They have arrived at this wasteland, and I do not envy the Supreme Court, because I do think that they are royally screwed. That they are going to be making an enforced error. That they are going to be forced to make an error either way, because either they will contravene their own legal structure and make the right decision and change the framework of the law itself in some sense, by introducing some kind of basic principle, which is a hideous aberration in the American legal structure, or they will slavishly make themselves prone to essentially legislatures that need to be rebuked, that should be rebuked. And if they do not do that, they are allowing some legislatures to pollute the coherence of other legislatures in some sense by amalgamating these rogue, rebellious legislatures who are rebellious against reason and accountability itself, especially in the in the context of what an election is supposed to be in the procedural life of a republic. Um, and in some sense, this really puts the Napoleonic corruption of law into very clear focus, because what I call the Napoleonic corruption of law is that when you give your legislature this paternal force in culture and society, when you say that it is the protector of culture, and it infantilizes the people who should be autonomously able to elect their representatives without interference. Um, but what happens if that interference is generated by the very body that has received legitimacy in the past? It's a self-refuting proposition. It is without integrity and accountability. Um, so it is a self-refuting value proposition. That is the kind of thing that the Napoleonic culture leads to. Is a kind of the people are so responsible that they're allowed to elect people that will impose a form of corrupted accountability. It's a bit of a paradox. Um, but sorry, I was going to make a more sort of grander polemic. Is that this is stuff that I'm trying to remember from my last recording, because I did articulate all these kinds of points much better in those other recordings. But essentially, the Napoleonic form of law does end up corrupting culture, because the legal culture itself, being devoid of reason and accountability, eventually, because it's not responsible to substantive principles of law, it's only responsible to the essentially the dictates of the legislature. Yes, within some context of constitutional protection and safeguards or something like that, which I would say are not not nearly as robust enough as is required in order to actually safeguard and protect necessary institutional or natural cultural values that are required to have a functioning liberal democratic, as a libertarian classical. Uh, anyway, that essentially, because the legal okay, this is a very, I'm trying to make a very nuanced point which I haven't articulated well yet, which is that the legal culture itself eventually becomes the compass direction that culture at large follows. That how the law treats you in terms of when you go to court, the only thing that you have to protect yourself is the legislature made something that gave you standing to it gave you a framework to work within. You can't stand outside of that framework and say, I disagree with this framework, other than relying on the Constitution. You can't discover your own law independently of these documents. You can't rely on general reason and accountability. That because you don't have the power to make legislation. So you're not in the same contest when you're coming up against state regulation, essentially. And so you don't have a natural body of values and principles to use as part of your defense or as part of your remedy or your recourse in a controversy. And you can't say that, well, I was put in a novel situation and I used my own moral compass, and actually the what I did um, resonates with the basic values and principles. I mean, in some sense, this is why you have juries. That the jury is meant to kind of get you out of this kind of hot water, and so you end up not having a system in which the individual has the effect to change the law itself, because the only thing that can happen is that the jury can quash or can support your claim in an individual case. That's it. So the jury can get you out of hot water um, if you appeal to them and you appeal to their greater sense of, their broader sentiments, their higher sentiments, perhaps. You can perhaps make esoteric claims and cases and arguments, but you don't have, at the end of that, the judge isn't going to rule in your favor and change the law. The judge is only going to rule in your favor in your case, and you have not discovered the new law and pushed forward the expansion of those principles. You have just used some sentimentality instead to protect yourself and your individual controversy, but you have not towed the line in terms of the whole collective. That belongs to the legislature. Now, to me, this is an intolerable disparity of power between the individual and the state. And it is orchestrated because the judge is effectively colluding with the legislature in an intolerable way. Because to say that the legislature creates the law, the executive enforces the law, and the judiciary interprets the law is actually not, actually, at the end of the day, it's not a viable dispersal of separation of powers. That there is still a separation to be powers to separation of powers to be had in my new role for the judiciary that has a closed system of ideals, but those closed system of principles and ideals of Roman legal maxims and things like that. Go look up the Roman law. De Groot, Johannes de Groot, the authors and commentators on Roman law, and just get into the substantive system of Roman law. I mean, the procedure of Roman law is actually terrible. You don't want to follow their procedural law, but their substantive law it has no alternative. It has no second. It's there's nothing that even comes up close to how good Roman law is. Um, and if you want to skip ahead, just look at the Dutch jurists. Um, uh, Not the modern Dutch jurists, but the Roman Dutch law jurists. I mean, this is why the Dutch were multinational. They had um, they were already sophisticated because of the Roman law, that they were able to develop multinational companies. I mean, the Dutch invented the modern economic era. Essentially, they invented public companies, um, and they did so to a large extent because of the sophistication that they were acclimatized to by by working under the Roman law. And anyway. What was the point that I was trying to make? I've just lost my thread. I was saying that the legislature, that judges I was talking about the separation of powers. Anyway, I've probably made my point enough times. So I guess I'm going to label this recording, um, and, and let me just tell you what I would consider the first. I guess first of all, the Roman law principles, you could put them in a certain order at some point. You could kind of connect them all up. I mean, obviously there are Roman principles, that deal with the law of contract, that deal because they, when you have a problem in the Roman legal system, you have very general solutions in some sense. There are no torts in the Roman substantive law because torts are made by the legislature in America. In in the Roman Dutch system, you have one action for damages. It's the action, the general action for damages, the lex aquilia, um, action for damages. The uh, and they have five general requirements, and then you have specific case law that deals with certain cases of a that deal with a certain thing that, well, these general requirements have then already been reviewed with reference to certain specific sort of legal complications and issues that would have a bearing on how those general requirements would apply. Um, so there are very few actions, um, but there is a lot of specificity and particularization within the digestion of those general actions, and they are all governed by general principles. Um, okay, and let me just say what I would consider to be the two prime general principles in Roman law. I mean, obviously, there'll be big ones that I'm not mentioning, but I would say like something like the first one would be the Audi. And let me just excuse myself that I do not know how to pronounce Latin, which is also a dead language, so perhaps you'll forgive me. Um, but the Audi alterem partem rule, the other side must be heard. I mean, these are very deep sort of things. I mean, the other side must be heard means that it's a lot broader than what you think it might be. The other side must be heard, uh, because maybe if the other side cannot say anything, then you have perhaps some responsibility to imagine what the other side must say or might say. Uh, and then I guess a kind of amalgamated legal maxim that I would that justice must be seen to be done. It's not that justice must be done; it's that justice must be seen to be done. Justice must be done transparently, so it must be done with inspection. It must be done with some level of transparent exemplification of candor. Because if justice is not seen to be done, then there is no way to know if justice was done or not. So if justice must be seen to be done and the other side must be heard, I would just say on the basis of those two principles, this whole election scandal falls short. I mean, obviously there would perhaps be more specific things, but just those general sorts of things is that you cannot say that justice has been seen to be done unless and how can you have a system of a Supreme Court that will probably deal with this kind of controversy, and they will not, with under their current legal auspices and their current legal commitments and structures or system or whatever, uh, they will not be able to make it appear as if justice has been seen to be done. Well, that's my reading of it. I think that they are captive, that they are confined. Um, that they are going to be making a forced error because their system is inadequate. Their legal structure itself is fundamentally inadequate. Um, okay, that's all. I just remembered some loose ends which I never finished pontificating about. So the interesting thing, I guess, is that I was commenting on the McCarthyist era and things like that, and what would be replaced by that, by the need to do that, is if you had a different kind of value based, um, principle based legal framework, because then you would it would force legislatures to concoct uh, legal devices that were fundamentally had judicial sensibility worked into them in some sense, and so they would have to conform to objective criteria. The effect of the law would have to be clear. Um, uh, so requirements like in the rule of law and things like that. But the essentially you would end up creating much more precise and correctly delineated lines to not be crossed. That the kinds of imposition and the kinds of restrictions that you placed on people would have to kind of be of the same quality as or same level of sophistication as judicial judgments. Um, and so, in some sense, the legislature and the um, judiciary would both be equally yoked by essentially principles which, in the sense of the legislature, um, would not contravene, let's say, all proper intentions that the legislature might have, but it would force the form of those intentions to be, let's say, already commensurate in a coherent legal structure and system or whatever. But so the legislature would not be bound uh, uh, in an in any kind of insufferable kind of way. Um, and in some sense, if they were bound in being prevented from doing what they wanted to do, it would be because that essentially what they want to do is in contravention of reason and accountability. So I mean, is to undermine sort of reason and accountability itself. But anyway, and so if they are going to impose onerous restrictions onto their own people, uh, that they will be structured with nuance and sophistication, and then the judges can actually uh, clarify any complications that might arise. But then essentially, you wouldn't perhaps have to have a McCarthyist era. You could have just created certain legislation about. I mean, I think that identity politics should have been quashed through substantive values in some sense, that because it breaches non-racialism, that you create essentially a clause enshrining non-racialism as a value that has to be upheld by anything that receives public money or something like that. Thus, essentially, the civil rights movement won't just be this historical cultural institution, but it will be enshrined. That non-racialism is a value that won't be enforced on people necessarily in the American system if you want to sort of strictly promote classical liberalism, but in terms of anything that receives any kind of state funds, that it must uphold non-racialism. And then essentially, you could say, well, look, you're contravening non-racialism. You can't teach this at a public university because it's morally defunct. It's morally deficient and defective, and essentially, it contravenes our culture as a civilization, as a society. Um, and you can have those private racist views or racialist views, however you want to classify it, but you can't do it with state funds. Where instead, what you have in fact is almost the opposite drive, where, for example, in California, they are trying to remove clauses for racial protection because they want to install affirmative action, which is not possible without essentially ejecting civil rights legislation, which I would say obviously didn't go far enough in some sense, because um, there is nothing on the books that it seems comes down on these academics and these universities, which are effectively poisoning um, the institutional underpinning of even a liberal democratic society in some sense, because you can't be a liberal society if you have that kind of I don't want to get into an argument. I don't want to now talk about cultural totalitarianism and the weird kind of backwards logic and the weird sort of hypocrisy and actually the overt fascism that is at the base of identity politics. I'm going to make a separate recording that reiterates my views on that. But basically, I mean, Hitler would have called these people useful idiots because they spread the conceptualization of the fascist worldview. They categorize people and interpret society in exactly the same way that fascists do. They aren't full blown fascists because they believe that racial chauvinism is the correct tool to arrive at a pure form of egalitarianism in a very um, expedient way. That where it's interesting that fascists just have the same values but in reverse order. Fascists also believe in equality. Hitler wanted everyone to have their own ethno-state and belong to their own ethno-state because that would be the philosophical or metaphysical precondition to prove and to also endorse the kind of the expediency and the drive to achieve national purity and racial purity, which would then essentially prove that their chauvinism deserved their own implicit belief in their own superiority, that you need to have equality as a way to engineer um, a kind of a self-righteousness in terms of their chauvinism. So it's like they want their chauvinism to be pure. They don't so they need equality as a prerequisite in order to vindicate that their chauvinism is deserved. Whereas the identity politics people, they need chauvinism to prove that their claim for some kind of strange pure equality that is going to be arrived at expediently, well, it's worth arriving at there as fast as possible, as proficiently as possible. Therefore, we're even allowed to use, sort of counter chauvinism, racial chauvinism as a means to an end. So it's like the antithetical mixture of their means to their supposed end, it is actually the same formulaic logic as fascism. It's just got the two the two values are just inverted essentially. Identity politics wants chauvinism to prove the purity of their equality, and fascists want equality to prove the purity of their chauvinism. Um, it is more complicated than that, but that's why I'll need a whole recording to go into that. But I mean, it is sad that, I mean, in my country, we actually have non-racialism as a founding constitutional value, and it has obviously been betrayed by these academics who have been effecting constitutional damages. They have been undermining the Constitution, which is not just imposed on states, on the state, is also imposed on civilians. Civilians are actually obligated to respect the rights in the Bill of Rights and to uphold the founding values and to give effect to the rights in the Bill of Rights, which are much more far-ranging than in the American absolute rights, because the rights in my constitution are limited by limitations clause, which requires a positive substantive measure, because essentially rights don't exist in isolation; they exist in the context of each other, and so it's a contest of values in some sense, and obviously there should be, in certain contexts, very clear and reasonable grounds to work out which rights should take precedence over which other rights. And this means that a litigant would be able to argue positive structure against positive structure. That that if the government is being sued because its legislature is being challenged, its legislation is being challenged as not making the right measure of limiting one right or prioritizing another right in a certain context or in a certain set of in a certain case or something like that, a certain set of facts in a matter. Um, Essentially, the biggest defense that the litigant has against the state is not to say you did it wrong, it's that you could have done this instead. And this would have been obviously better. This would have been obviously a better balance. So you don't have to prove a negative against the state and say, well, that's wrong because it's objectively wrong. You don't have to say that. You just have to say this would have been better and this would have been more intelligent. And what you're doing is a lower form of synthesis, and it is not justifiable because you could be giving effect to other rights which you are quashing in some senses. And it gives the individual the possibility to defend their own navigation, their own individual navigation within an ambit in which the individual and the state are on an equal plane, on an equal playing field. It gives much greater effect, I believe, to the classical liberal sensibility and culture. It empowers the individual. This does not occur um, in the Napoleonic corruption as I have described it. Um, the individual is always a little fish relative to the behemoth of the state. And I mean, I know that there is some replication of that kind of understanding in the American legal system, but it is just uh, anyway. My legal system is not is not being followed as it should be, because it's basically drowning in this toxic atmosphere which is created from these other inadequate legal systems. And so it gives people in my country the belief that our legal system is not in a different league, in a different, and so it has actually been diminished. It has been betrayed. But that is also because there's a lot of political bad faith, and because my country is a young country with a young constitution, and so it has been steamrolled by, let's say, historical forces that have blunted the sophistication and superiority of its legal structure, which has even been polluted by its highest ranking judicial officers that openly speak about identity politics and that kind of fascism. And, it is a corruption of the law, because essentially it means that the legislature, I mean, it's just like the Nazi state. I mean, the Nazi state never stopped being a democracy. They never once stopped being a democracy. They made everything that they did was legal, because the legal positivism. Isn't it wonderful? That's why all these so-called liberals are legal positivists, because they have the same formulaic set of beliefs. They don't believe in normative values. They believe in prescribing moral pictures to people. I mean, that's another thing that's fundamentally undermined by this legal system, which I've described many times, that makes the American system inadequate. Is that what ends up happening is that when you have to blindly follow whatever is prescribed by your legislature, you are already placed in a diminished form of integrity as a citizen, as an individual. You are made a child, a moral child, and the moral authority of the legislature, which is unjustifiable, is unchecked, essentially. It is checked only by sparse, sort of very sparsely, fragments of what might be salvaged from the framer's intention, in terms of what can be extracted from the wording of the Constitution, which does have some principles, but it doesn't have enough substantive values and principles. And the ones that it does have been contorted in order to facilitate the overarching system, which is that the legislature must be seen as the only thing that makes the law. And therefore it can obviously undermine reason and accountability. Because the form of the law, the legal positivism, ends up becoming the final arbiter at the end of the day. And you have to hope that there is a glimmer of something that you can shake around the Constitution and find some shred of something that you can interpret into your magic 8 ball to circumvent some obviously egregious advent, which is, which I think is somewhat probably inescapable in the current American, what I've described as the present constitutional crisis that is looming in America, which I think it will be a verdict on the American legal system, because, as I've said, in the Roman Dutch legal system, that essentially one of the most basic principles that are one of the first axioms, is that justice must be seen to be done. And I do not see how that is possible in the American legal structure. It is not possible for justice to be seen to be done in this instance. It will not be done. It will be unsatisfactory. Justice will not be seen. It's not that justice won't be done, it's that justice will not be seen to be done. And that will be an indictment against the entire structure. Justice, according to how it is structured, perhaps will be done, but justice will not be seen to be done. And so there is a gap. There is a gap between real culture, real morality, real common sense, real accountability and reason, and the structure of the American system, which is, as I've already described, inadequate. Okay, I think I've touched on a lot of things, so that's all I will. There's a lot more. I'm going to make a separate recording on identity politics, but anyway.